Modifying Trusts After CCA 2023 52018. That is the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Margaret Van Houten, ACTEC Fellow from West Des Moines, Iowa. IRS Chief Counsel Advice 2023 52018 was released at the end of 2023. It rules that a beneficiary would be making a taxable gift by consenting or acquiescing to a trust modification. ACTEC Fellow Steve Gorin from St. Louis, Missouri, is with us today to discuss the CCA's true scope, how it affects designing trusts when drafting, and some considerations when modifying trusts. Welcome, Steve.
Thank you, Margaret. Glad to be here with you. So the CCA is a shot across the bow. So we know that estate planning clients can never be happy with whatever trusts are ever created. There's always buyer's remorse, or down the road, circumstances change, trusts need to be modified for one reason or another, particularly in the age of perpetual trusts. So what are you going to do when a trust needs to have something happen to it to make it a more workable arrangement? And that will wind up being a trust modification of some sort. Lots of different ways to do trust modifications, whether it's decanting or it's a trust protector or some other method. Now, the IRS basically says if you're going to change a beneficial interest in a trust, then there are gift tax consequences. But they don't define what those gift tax consequences are. In fact, in a private letter ruling several years ago, the beneficiary exercised a power of appointment, inter vivos one. So some assets were leaving the trust, and the IRS said, well, some assets are leaving the trust, and it could be that there's so many assets left in the trust that it really didn't affect the beneficiary to have those assets leave the trust. So maybe that was a gift with a nominal value, but it's still a gift. So this CCA is really nothing new in terms of it's really just going with the IRS's longstanding position that a change in the beneficial interest has some gift tax potential. And if you have a beneficiary who affirmatively consents, which was really the so-called facts of the CCA, then you're definitely having some kind of a release. We know a release and a lapse are a little bit different for gift tax purposes. And particularly if a beneficiary doesn't take an action, does it really mean that the beneficiary is taking some kind of affirmative decision making? Beneficiary might not even understand what's going on, or the beneficiary might feel it's just not worth it to challenge what's going on. So it really kind of proves too much to say, well, if a beneficiary refuses to object, just doesn't object at all, that they're making a gift. So the CCA cites a particular regulation, 25.2511-1 parentheses G parentheses 1, when it's saying that there's some kind of gift tax consequences when anything happens with the trust. What it doesn't do is mention the paragraph that immediately follows that, Regulation 25.2511-1 parentheses G parentheses 2. And in that regulation, the trustee is a beneficiary and has ascertainable standards for distributions to that trustee beneficiary and to other beneficiaries. And under that regulation, when the trustee beneficiary makes a distribution to other beneficiaries, that beneficiary is not making a gift. So you have this regulation that says money is leaving the trust, it's going to somebody other than the beneficiary who's basically making the decision for that money to leave the trust, and yet there is no gift. So why is that? That's because there's an ascertainable standard there. And an ascertainable standard is something that a beneficiary has legal rights to try to enforce. Now, it can be difficult to enforce those legal rights in terms of you got to prove the abuse of discretion, but nevertheless, here we have that there are some legal rights that are at stake here, and the other beneficiaries do have rights, and those have to be considered. And just the fact that the money leaves the trust doesn't mean that that beneficiary who's the trustee should sue himself or herself for letting money leave the trust. The trustee's action was very much authorized. You might even say it was almost required. It is still discretionary, so it's not totally required, but ascertainable standard, it is an enforceable thing. So the bottom line is that the regulations don't support kind of a Chicken Little thing that says anytime anything happens with the trust, that there's a gift going on. You have to look to see what the beneficiary's rights were and how strong they were. And if the rights were very little for the beneficiary to resist the trustee's actions, then the beneficiary does not have a duty to sue. And there's no gift tax consequences to doing that. So when you design trusts and you're drafting a trust, what you wanted, and you know that things are going to happen over time and the trust may need to be modified, it's good to have things that are clearly within the trustee's purview. You might have some kind of a power of appointment. You might have a trust protector. You might also just have the trustee being able to make distributions in the trustee's sole and absolute discretion without any standards. Because when you have such broad latitude by the trustee, it's really difficult for any beneficiary to argue that the trustee was doing something wrong when they exercise that very, very broad power. So the idea here is to attenuate the beneficiary's rights to make it more speculative for a beneficiary to maybe successfully mount a challenge. And then the IRS has a much more difficult time saying that the beneficiary should have mounted a challenge. And then when you go to modify the trust, the beneficiary has a potential cause of action. What is the scope of that cause of action? Is it going to be big or little? Well, in the Uniform Trust Code states, which are the majority of them, the trustee can be sued throughout the trust's entire trust administration up to 5 years after termination of trusteeship or the trust, unless the trustee provides a notice to the beneficiary with a specified time period. Typically, that's 1 year, but different states have different time periods. And if the trustee provides a sufficient notice to the beneficiary has only a limited amount of time to object. So if you provide that notice, then you can cut off the beneficiary's time to object. And the sooner you cut off those rights, the smaller the lawsuit might be. Because if you let things fester and compound over decades, then it can be a much bigger lawsuit. That gives the IRS a much better position that there's some big consequence. So I would recommend, if you are going to modify a trust, do whatever notice is required to get the statute of limitations running so that we can cut off the gift at whatever the smallest level might be. So I hope this helps you in drafting and administering trusts, and look forward to perhaps talking with you further about it some other time.
Thank you, Steve, for updating us about this important ruling.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.